Good morning, everyone. Welcome once more to the Aurum podcast. Today, the 20th of March, 2021. Sorry, 2027. Sorry for that. I'm taking ourselves far, far into the future. Well, thank you for joining us. My name is Anthony Kuria. I am very glad to be your host today. I'm looking forward to a beautiful, beautiful day, a fruitful time of discussion on all matters HR. Aurum podcast is a podcast that we do here at Aurum Consultants where we educate on all matters HR and risk advisory. And I'm so glad that we have a panel today that we will discuss issues that appertain to compliance. With me is our in-house HR consultant, Zipporah Kuria. Welcome, Zippy.
Thank you. Good morning, all. Thank you. I'm glad to be here this morning.
Yes, and with us today is a HR expert and a man of God. His name is Tom Kamaliki. Tom, karibu sana. Tom, you could unmute yourself, please.
Thank you. Thank you so much, Anthony and ZP.
Yes. Yes, thank you very much, Tom, for coming, joining us today. This month, as our audience knows, this month we've been discussing issues concerning compliance. This has been a month where the theme has been compliance in the workplace. And specifically, today we want to talk about issues relating to contracts and managing of terminations to ensure compliance in the workplace. This is a hot topic, Tom. I believe, with this time that we have today, we will be able to dissect very well issues regarding both employees and employers, because a contract is not one-sided. It has the side of the employee who signs and bind themselves to a certain contract, and the employer also who binds themselves to meet certain obligations of the contract. And like any other contract, it has a beginning and it has an end. And doing so in a manner that is prescribed by the employment law is something that we want to discuss today. So, Zippy, I would like to hear from you. We've been talking this for a while, talking about, things to do with compliance. We've talked about what is statutory, regarding the government, what the government wants on us, the issues to do with making sure that you meet the bare minimum that the government, that the law requires of us. But now we have come to the issue of contracts between employees and employers, and the fact that there are compliance issues there. Let's start with the fact that what is an employment contract? If you could give us a background to
that. Thank you, Anthony. I'm glad we have Tom here this morning, who is my senior in matters HR. And I would want to start by saying a contract is a beginning of any employment agreement with an employer. So as an employee, when you get engaged, the first thing you probably get is a contract. So I would say a contract is a binding agreement between an employee and an employer. It signifies what is supposed to be the expectations, what is supposed to be done by both parties. So a lot of times we think a contract is one-sided, it's supposed to just cover the employee. But I would want to actually clarify that the contract also does actually cover the employer. What are the responsibilities of the employer? What are the responsibilities of the employee? When we look at contracts, we need to refer back to the Employment Act and see what does the law require us to do. When we talk of an employment contract, sometimes we normally look at it from a place of Do I give a contract? Do I not give a contract? But I think that is something we'll discuss as we go along. So I would say a contract is a binding document between the person who is being employed and between the employer who is giving this document, and it signifies or it outlines what is supposed to happen within the contractual period. Doesn't matter how long it is, but this engagement we are having, this relationship we are having, me and you as employer and you as employee, what are our terms of engagement with each other, so that there's clarity on my expectations as an employer, there's clarity on my expectations as an employee. So in simple terms, I would say it's a binding document between two people who are willing to engage each other in the employment space.
Right, right. Tom, if you could give us a hint from your perspective, what you would say an employment contract would be?
Thank you, Anthony. And just want to echo on what ZP has said.
Yes.
It's actually a relationship. It's a document that actually tries to stipulate the relationship between an employee and an employer, specifying the terms and conditions of employment, which is very, very clear. And just to echo on what ZP had said, you find that the Employment Act actually says that there are two types of contracts. It can actually be oral contract, it can also be a written contract. And by that is also trying to categorize the kind of employees who are there. And you find that there's a casual employee and there's a full-time employee, and a casual employee whose contract actually ends at every close of the day, every day. And you find that there are piece rate workers. In such kind of situations, there is no written contract, because you just measure here up to there, and that's all. That's now how oral contracting also comes into play.
Yes.
And now the element of the now written contract, and we say that any contract at least more than a month and aggregating to more than 3 months, it should actually be in written to specify the terms and conditions. It might be open-ended or it might be fixed. So you find that in an open-ended contract, there is no time limit, but definitely there are terms and conditions which can actually contribute to that kind of contract being terminated, but following the law. And there's also the aspect of a fixed term contract. A fixed term contract where the employer specifies that at the end of this contract, we are in this relationship for this period. And you find that some fixed contracts will specify and say that this contract will not be renewed at the end of this contract period, while others will specify that it can be renewed with performance and funding. So you find that they normally do what we call tranches, and there's a rolling contract on annual basis, and they renew based on the funding that is available. So you find in such conditions now fixed term contracts become very ideal.
Okay. Thank you, Tom. Thank you for giving us insights. Oral contracts, fixed contracts, rolling contracts.
Yes.
And written, yes. Those are great insights. And I can already see comments coming in. People saying, Thomas Machete saying, thanks all for this topic. Indeed, Thomas, indeed, Joseph, this is a very good topic to begin to discuss now.
Actually, if you could allow me to just add a bit on what Thomas said. Again, I think as employers are working on these contracts, it's important to also understand the critical elements of a contract. What is supposed to be actually on that contract? For sometimes, and this I've seen from experience, where you see a contract drafted, but that contract in itself is opens another door for you as an employer that could be challenging legally. So I think it's important for you to understand also from the Employment Act what is supposed to be in this contract. Terms of engagement. When you're looking at what the law says, the names of the employee, their address, looking at what salary they're supposed to be paid, looking at the number of hours they're supposed to work in. All those details need to be very clearly defined in the contract, so that again, there's no gray areas when it comes to the employee and them understanding what is my obligation. So even as an HR person, as you're drafting this contract, it's important for you to make sure every aspect of this contract is covered. This employee understands. The law is also very clear about employees who might not necessarily understand English, because again, you find most of our contracts are drafted in English. They are not drafted in our mother tongue or in Kiswahili. So where you find, for example, you have engaged people who are not well conversant with the language you're using, it's important for you to also explain it to them in a language that they understand. It's your responsibility as an employee, it's your responsibility as an HR officer to make sure the employee understands the contents of that contract and that they consent to it. So I think that is what I wanted to add.
Thank you, Zippy. Actually, now there's something as Tom was talking, I realized he
Anton.
Yes. Yes, it looks like we cannot quite hear Tom. Yes, yes, Tom, you were discussing something. Unfortunately, the communication was disrupted a bit. We couldn't quite hear you, but yeah, let's continue. As we continue discussing this matter, and I'm sure Tom, you'll bring it up as we talk. There is the issue of engaging an employee. Yeah, is it a must that you have to issue a contract? And if so, what is the benefit? I don't know. Tom, can you hear me? Can you be able to hear my question? Yes, the question would be, if you're engaging an employee, why must you give a contract? What is the benefit for doing so?
Thank you so much. Are you hearing me nicely?
Yes. Now we can hear you.
Are you hearing me?
Yes, very well.
Thank you so much. What I was saying is that it's very important to issue a contract when you are engaging an employee, and the actual Employment Act actually states clearly that for an employee who is engaged for an aggregate period of 3 months, a contract must be issued and it must be in writing. That's very important. But for other areas, like when you talk about the peace sector or whatever, that's exactly where you give an oral contract. And it's very important because a written contract is something that is witnessed. It's something that's evidence. It's a backup that in any event that an employer can go against what he had drafted or what he had put in writing and signed. That's something you can actually produce before the court of law and say, these are exactly the terms and conditions that I was actually enrolled on, and I believe my employer has gone against them. And you find out that when it comes to the contract, it's actually both the employer and the employees who are benefiting, because it is actually a contractual agreement, and there are certain parameters that the employer has also set, which you are also supposed to meet, and is going to undertake a performance evaluation based on the contract that he has actually given you. So you find it's beneficial to both parties, the employee and the employer. The employee comes to know or becomes aware of terms and conditions that is actually enrolled on. And those conditions, the way Zippy said, they must be conditions that are legally conditions that are actually based on law. If at all is a matter of hours, what does the law talk about working hours? And it's very clear that an employee should not work for more than 60 hours per week. If someone is giving you a contract of 80 hours per week, then you find that is actually contradiction of the law. What about the issue of the shift? They should also be included in the terms and conditions so that you know I'm working on shifts. If your shift comes, you have actually to attend. What about the public holidays? You should also state the public holidays you are entitled to so that you know this is how I go about. What about the reporting time at workplace? What about the living time? Is there any 50 hours that the employer can also include, so long as you work within 8 hours per day? Is there, even if it's flexi hours? is that aggregate 8 hours per day. So a contract is very, very important. It's a binding document, something evidential, something you can put across and you say here is actually our relationship. It's like a marriage certificate. To confirm that you are actually married, yeah, fully legally, you must be able to produce a certificate.
Thanks, Tom. You brought in some very wonderful insights concerning why it has to be there. Yeah, why do we need a contract? At what point do we need a contract? What benefits are there to the contract? I like the way you have brought the issue of you're safeguarding the employer's welfare. You're safeguarding the employees' welfare in both areas. They both understand this is how. This is what we are discussing about, and making sure that the way you're saying, like a marriage certificate, we all know where we stand and we all know where we are going. Zippy, what's your short comment on the same?
Anthony, let me say that from experience, and sometimes I don't understand whether it's a lack of knowing, or sometimes as business people, we think when we don't have contracts in place, it works better for us. The truth is actually it works against us. Because when I look at engaging an employee, if I don't clearly tell them my expectations, if they don't understand what is expected of them, then we leave a lot of gray areas where everyone is trying to figure out what is expected of me. And a lot of times you'll find businesses that don't have compliance in this particular area, they struggle. Why do they struggle? It's because you will find the employee will do what they know best. They don't know the framework they're supposed to work within. So they will come in the morning, they will do, you are not coming, your work is a clerk or your work is a driver. So you will do the bare minimum based on what you know best to do. And what happens most of the time, employers actually find themselves in situations where an employee is not performing, or the business is not performing. And employees sometimes end up being blamed unnecessarily because you have not told me your expectations. So how do you expect me to meet your expectations when you have not clearly defined the same? This touches on things like job descriptions and all that. So when we're looking at the job, the contract of employment, there's a lot of things that are covered in it. And I've seen someone asking that particular question, what are some of the things that are covered in the employment contract? We need to ensure, we have covered, like Thomas said, we have covered what is the wage for this person you're engaging. What the working hours, what is the expectation in terms of working hours, so number of working days. What are you expecting as an employer? And again, your expectations should be guided by the law. Don't wake up in the morning and tell an employee, I expect you to work 100 hours in a week. What does the law say? I have seen scenarios where employers will say, my employees are going to work 7 days in a week. I'm going to pay them overtime. While that is well and good, you have to remember the Employment Act is very clear. An employee is entitled to at least one rest day a week. So even as you're saying you're going to pay all this overtime and all these things, then have you given a provision for this employee to rest? Assuming the employee, and I've seen this a lot in where there's a bit of a low-card employment or casual workers, assuming the employee comes and saying, ninataka hiyo pesa kidogo, are you thinking about this employee after a while is going to start getting burnouts? Are you thinking about this employee will get burnouts and they will start dropping the ball somewhere? So as an employer, you actually stand out to lose. So it's important, what we are trying to say here, it's important for you to have a written contract that you give to employees that you are engaging. And when you don't have that written contract and it's an oral contract, the truth is, so long as you have engaged this employee for more than a month and, in aggregation 3 months, the law actually recognizes that as a contract. So it works against you as an employer if you don't have a written contract.
Wow. I can see our comment section is on fire. I can see it's on fire. Some of the questions that are coming here are very interesting. I think some of our listeners are people who are well informed on HR matters, which is good. We appreciate when professionals come in because some of the questions that come in enable us to discuss further what's the topic on discussion, and then we are able to move on. I can see someone saying Nelson Saitoti, thank you Zipporah for that addition. I think that was on the first question. Jared Odindo, your question you asked about what's composed, what is composed in the employment contract, and I think Tom Kamaliki and Zipporah also alluded to the question that you've asked. Joseph Machete, thank you. You've also asked we touch on the minimal daily wage based on the labor law. That's something that we'll keep discussing. Dominic Madeka, I like the question you've asked. What is the sick leave entitlement for a staff on a 3-month contract? I can see now that's something that I hope we'll be able to touch on even as he comes in. Even as we continue discussing. Jackie Mora, you said thank you, Tom and the hosts, and you've talked about the pandemic and people working from home or remote working. Should contracts be rewarded, especially on working hours? Working hours, location from home. Issues to do with salaries. Now that's Jackie. That's an emerging issue out there in the workplace. I've seen even internationally, in the US, Europe, they're still trying to grapple how then do we have this matter of working from home, working without supervision. That has also brought up other matters like employers trying to get tools that supervise you, whether you're working ama umeenda kwa loo ama umeenda kukula, you're not on your desk. Now that also now brings other issues regarding intrusion into privacy, because you see, one of the things we've realized is that as people work from home, then issues of privacy come up. So these are great insights. Simon Kisilu, thank you for commending our guest. Thank you for commending our guest. Now, as we continue, Zippy, types of contracts. Let's discuss. I know Tom had discussed a bit about oral and written and all those kind of things, but give us a hint. What are the type of contracts that we can engage in as employee-employer in regards to the whole umbrella of compliance?
Thank you, Anthony. To our viewers, it looks like we have lost Tom, but we are trying to bring him back. But let me try and respond to that question, the types of contracts. So we have various types of contracts that can be given to employees. One will be a permanent contract where the contract has a beginning, but it has no end. The end would probably be a retirement age. So that is one kind of a contract that you find employers giving. The other type of contract you find given to employees will be a fixed term contract, where the contract is very clear when it starts and when it ends, and it clearly dictates if it can be renewed or it cannot be renewed. So when it's a fixed term contract, when it ends, then that relationship ends unless the employer actually extends and renewal to it. It can also be a fixed term, but is renewal, where again the contract is renewed upon its expiry. The other type of contract would be a part-time contract, where you find an employer does not necessarily need an employee 5 or 6 days in a week. Maybe they need them 3 days in a week. But again, what actually dictates the terms of that engagement is they have to be very clearly stipulated. How many days of a week do you expect me to work? How many hours do you expect me to input? What is the salary? What are the guiding principles of this contract? The other contract I'm thinking on top of my head would be a short-term kind of contract, although again it would lie within the contracts I've talked about. So again, you can have a situation where you only need an employee for 3 months, or you need an employee for 6 months. Then that becomes a short-term fixed contract, where the contract ends and that relationship comes to an end. So even as we are looking at the types of contracts we are giving to employees, I think it also needs to be dictated by what is the kind of work we expect them to do and when do we expect this kind of work to end. You'll find scenarios where like in the NGO sector, most of their contracts you might find they are fixed term contracts. The contracts are not long term. While you go to corporates where it's a profit-making entity, the contract could be open. It's a contract that has, what we call permanent and pensionable. So again, really it's dictated by the sector and dictated by what needs to be accomplished at the end of the day.
Okay, so what you're saying is that there are several types of contracts out there, dictated on mainly from the employer's point of view. What is the work that is available to be done? Is it short term? Is it long term? And depending on the duration that needs to be done, then do you get casuals to come and do it? As Tom said, it ends at the end of the day. Do you put people on short-term contracts, 3 months, probation of sorts, before you decide whether to hire them or not? Do you put a fixed contract that is renewable or non-renewable? Unfortunately, our guest Tom is struggling to get back into the studio, and he's there. He is. Oh, Tom, welcome back. Technology can let you down when you're not quiet.
I don't know what happened. I disappeared.
Don't worry. You have reappeared. You disappeared and reappeared, and we are glad that you have reappeared. Now, we were discussing about types of contracts. I know you had mentioned a few, but could you briefly give us several of the contracts that are there when you're hiring employees in regards to making sure that you're compliant?
Fine. When we go through the Employment Act, definitely we are guided on things of compliance.
Sure.
We are talking about oral and we are talking about written.
Sure.
And they are saying that when it comes to now written, the only compliant issue is that any employee who works for an aggregate period of 3 months must be given a written contract. Then we came and talked about open-ended contract and fixed term contracts. Those are the issues that we know about, or those are the contracts that we know within the employment cycle. And you find that the fixed term contract and the open-ended contract, the open-ended has no time limit, but we are advised legally that when it comes to issues of managing, you must manage them within the legal framework. And even when it comes to termination, you must terminate an employee within a legal framework. When it also comes to the fixed term contract, it's that it has a specified period of the start date and the end date. And here we have to be very careful. This is where most employers have actually been goofing. That when you give an employee a fixed term contract and you state that it starts this today and it will end next year, September 30th, and you come and just say that your employment contract ended on a fraction of time. They call it a fraction of time. We must also be very careful exactly. If this is a fraction of time, did you notify the employee? Yes, of course. What are the parameters surrounding this contract coming to an end? And it cannot be. Is it that it was also a project that was coming to an end, or is it a 5-year project, but you are denying this employee to continue? If you are denying this employee to continue, what are also the conditions surrounding that? Are there issues of underperformance? Are there issues of discipline? Those are the issues you consider. And you say that when I'm not going to renew this, it is because Tom did not actually perform, or Tom had this issue of discipline. So for that matter, this is the evidence I'm going to allude, even if the matter goes to a next step of trying to do what? Maybe you want to litigate. So there are several parameters. And we need also to be very careful, Anthony and Zippy, and with my colleagues who are watching, that this element of renewing contracts subject to performance and funding. If you come and stop an employee's contract arbitrarily, and the funding was there, the performance issue was not there, then the issue is, why are you stopping this employee's continuity of the contract? Also, there is a litigation matter. And if this employee, you've been renewing his contract, 1, 2, 3, you see the first thing you in law is that you have what you call a legitimate expectation. Legitimate expectation. This employee will have a right and say that my contracts were being renewed for the last 5 years, and you had actually developed a culture of renewing. It means you had also made me expect what you call psychological contract. I was expecting a renewal. So those are some of the parameters you need to be very careful with.
Wow. Tom, you have brought up issues. You have made me go back to my past. You know, the last employment I was with one of the major banks. The contract was for 1 year, and the date was 15th of December.
Yes.
The 15th of December arrived. Me and all my other colleagues who were employed at the time, we were just told one morning, 15th of December, nobody spoke. Around 1 in the afternoon, we were told, Anthony, close down your laptop, switch off everything, go to your manager, handle everything, go. We were not given appraisal. We were not told why it ended. We were not told whether the project was going on. Yeah, so those are the things. You're discussing things that happen out there, you know,
exactly.
out there in the world. Yes, those are the things you're discovering. And I like the way you've given the analogy that beyond what is on written paper, there is a psychological aspect. Now, as we draw to a close, I want to find out, the last point that I wanted to find out from us today is, how do I safely separate with an employee? Zipporah, probably you could briefly tell us. Now I'm an employer. Imefika wakati, it is time to shake hands and say that it's been real, lakini ni wakati wewe uende huko na mimi niende pande hii. As an employer, employee. So how can I safely, from a compliance perspective, separate from an employee? Zipporah.
Thank you, Anthony. Thank you, Anthony, for that question. I think one of the things that we need to understand as employers, as HR professionals, when we are engaging someone, there's a beginning and there's an end of that engagement. And there are many reasons why we separate with employees. And one of the reasons could be an employee has attained a retirement age. It could also be a situation where the contract is coming to an end. What is the framework? What are the guiding principles of ending this contract, assuming that this is a fixed term contract, like what Tom alluded earlier? Because if you are renewing contracts every year and all of a sudden you have to end a contract abruptly, are you going to create a scenario where you're going to get into a legal litigation? So as an HR, as an employer, you need to create a framework on what conditions that contract can come to an end, and it's clearly understood by the employee even as you engage yourselves. It could also be a disciplinary issue, and I think this is where many challenges come upon when we are having to separate with employees because of disciplinary. It could be an issue of performance. Again, I've seen scenarios where we are saying you're not performing as an employee and we end up terminating you. What are we put in place to measure that performance? Is it a practice that we are making, or do I wake up in the morning and I decide you're not performing and I have no backing that would back me up to terminate on a performance situation? And these are very sensitive areas when it comes to separation. Separation also doesn't mean it's the employer doing the separation. Employees also do separations, and they can also make a decision to leave. So again, as an employee, what does your contractual agreement say? Because it's also not your right to wake up in the morning and say, I am going to leave employment. You need to honor the obligations of the contractual agreement you have with your employer. So actually, this goes two ways. But a lot of times we tend to look at it from an employer's perspective. Now, let me address it from an employer's perspective in terms of how do you separate safely. Number one, I think you need to understand the contents of your engagement with your employees. First of all, have that clear understanding and know when it is that you can be able to offload an employee and offload in a legal manner that will not put the company in jeopardy. The other thing I would say, have a clearly defined process of how you separate with employees. Again, this takes us back not only to the contract, but also to the HR policies that you have put in place. Do employees understand in the event that I'm to be terminated, this is a process that will be followed for me to be terminated. If I look at a disciplinary situation, and this is another whole subject we probably need to dwell in another topic. When you look at a disciplinary situation, what is the process you have put in place? What is policy, the disciplinary policy you have put in place that will guide you to getting to the place where you can offload an employee and offload that employee in a way that is actually mutually understandable? It's not always easy to separate, but you have to make sure however you do it in a way that will not bring any challenges to the organization. So I would say, number one, as an employer or as an HR professional, understand the contractual agreement, understand the policies you have put in place that will guide you when it comes to offloading. I would allow Tom to give a bit of input as well on that subject.
Yes, Tom, I'm looking forward. What's your view how to separate safely, legally?
Thank you, Anton and Zippy, and thank you, Zippy, for that insight. I mean, the obligation of effective separation, humane separation, is both sides, the way Zippy has said, the employee and the employer. Fine, an employee can wake up one day and say that I want to leave, and the issue is, yes, you want to leave abruptly. What does the law say? There is also a provision for a waiver of a notice, which is actually 28 days. 28 days based on February, because February has 28 days, and that becomes a month. So you find that you will talk to the employer. I've had such a scenario when I was working somewhere, and the employee wanted to join a husband in South Africa, and there was an urgent issue. And we had to waive the 1 month notice because the employer understood the situation. But it's not a matter of that you want just to jump into another job because they want you. You have to pay, because the law says if that situation happens, then you have to pay 1 month in lieu of notice. That is the same way the employer can do. Anyway, I want to dwell very fast on the issue of the employer. When it comes to the issue of separation, it's very sensitive. And actually, there are a lot of litigations in court regarding unfair dismissal or unfair termination. The most important thing, both sides, employer and employee, the element of fairness must be addressed. That is very paramount. So they will look at the process of termination. Yes, even if it was because of reorganization of the operations of the of the company, the issue is what is redundancy. Number one, now redundancy is defined not in section 40 alone. That's the mistake employers make and HR make. Redundancy starts in section 2 of the Employment Act, which defines redundancy as a loss of employment due to a fault of the employee. And then now you declare what we call abolition of office because the position is superfluous. That's the term they use, superfluous. Superfluous meaning it does not add value. Then the issue is now, if it does not add value, what criteria did you use to identify this position for being not superfluous? So the element of criteria for selecting an employee for termination, Anthony and ZP and all of us who are watching, is very key, and that's exactly what the courts are looking for. You might have a good intention, but the process you follow is
It looks like there is a bit of hanging there by Tom. There's a bit of interruption, but yeah, Tom is bringing something very powerful, issues to do with me. And now, as we close, one of our I've seen very many comments, very many useful comments that have come up. I appreciate all of them. We cannot be able to go through all of them at this hour, but let me highlight what Christine Ojunga requested about. She talked about when an employee has a binding contract of say 2 years, and a donor, say if it's a donor-funded issue, the donor stops funding. Unfortunately, I can see Tom has been thrown out. I don't know whether Zip you can be able to give very briefly. I know we cannot be able to answer all the questions here, but this is something that comes up every now and then, that a donor has ended funding, so the entity that is employing this staff has no money to handle it. So how do you handle an employee who takes a an employer to court for non-payment of dues due to a contract that funding stopped. From your perspective, how can you say?
Thank you, Anthony, and thank you for that question, Christine. Let me start by saying when you're engaging an employee and giving them a contractual period of 1 year or 2 years, you have actually promised that employee they will have a job for that specific period of time. Okay. Now, when you abruptly disrupt that, then the employee has a right. So when you're disrupting that, you need to have the resources for you to be able to actually honor the obligations of that contract and pay the employee their final dues. So you can't end a contract and expect an employee to just walk out without their dues. Of course, it's not right. Yeah. Number one, is not right. Legally, it's also not right. An employee is entitled to their final dues. So when you are separating with an employee, number one, you have to make sure you follow the law clearly. When a contract is ending in 2 years and you terminate it after 1 year, you need to ask yourself the question, do I have the money to pay for the remaining part of this contract? Because you have promised this employee a contract for this period. So we need to be very careful when we are giving employees contract, and also have discussions with the donors or with the employers or the directors. We need to have a conversation and see, is this achievable? Is it better to give a shorter period of contract as opposed to giving a longer period of contract that is a fixed term contract? Because if it's a fixed term contract, the truth is, if you go to the courts, you will have to pay for these deals. Yeah. The other thing I would say, as an HR person, if you're the one handling such a situation, before the donor withdraws or before you do your budget, it's important for you to make sure the donor understands how the law works in Kenya. Because you will find, for example, the way the law works in Europe or in America or in any other country that is not Kenya might not necessarily be the same. So you need to make sure you also help them understand how our employment law works here. Otherwise, as an employer, as an organization, you find yourself getting into a challenging situation. So I would say, if you are the HR person handling this situation, the best bet would be try and resolve this issue out of court settlement, as opposed to allowing it to go through the court process, because the truth is you will end up losing such a case. I think that would be my take on that.
Wow, wow. I wish Tom was here. Unfortunately, looks like he was thrown out. He was unable to reconnect, and I can see our time is long. Has really gone, and we are more than our time is past. I appreciate all the comments of the viewers.
Allow Anthony, allow me to just comment
Yes.
on one or two. And someone asked about the minimum wage.
Sure.
And I would want to assume this is an employer who is seeking to understand what is the minimum wage. Again, the law is very clear when it comes to the minimum wage. And the minimum wage will touch across different sectors. So you might find the minimum wage of a driver is not the same minimum wage for a cleaner. The minimum wage for Nairobi is not the same minimum wage for Mombasa or Kiambu or Machakos. So you also need to actually equip yourself by getting this document that is available actually online, that is available in the Kenya Gazette notices, and make sure you understand, if I'm employing this cadre of an employee, this is a minimum wage I can give to this employee. Okay. If you don't do that and you end up paying an employee, let's say 10,000, and they Nairobi, for sure you are paying that employee below the minimum wage. And when you have a legal challenge, then what happens? You have to pay backwards, you have to pay with a lot of penalties. So what I would say to Joseph, kindly just Google this document. It's available. It covers different job titles. It covers different sectors. It covers different municipalities, so that you are very well conversant of what the minimum wage is.
Wow, thank you, Zippy, for that. I can see today we generated a lot of questions, lot of comments. Unfortunately, we cannot be able to handle them all, answer them all within the short period of time that we have. But we are noting them. We appreciate the conversation that we've been having today. And if you would like to know more about, you'd like to understand more about what what we would more about whatever we are discussing today. Please log in next week. Next Saturday, we have a seminar that will be 2 hours. We'll have a 2-hour seminar where we will discuss issues regarding compliance. What we've been discussing this month, we'll bring it all together, and we'll have a panel of experts, someone like Tom. I believe Tom will be there together with someone else, and where we'll discuss in depth issues regarding with compliance of contracts. I know this is a topic that both employers have found themselves in trouble. They want to understand better. Employees, like I gave my own example one time when I was working and I found myself in trouble. I mean, I found myself kicked out like like a trash. Umetupwa nje kama takataka. These are things that we all go through, and it's very important to have experts like Tom and even Zippy herself. She's also an expert, and we can be able to discuss this better. So if you'd like to know more about Aurum Consultants, our contacts are at the bottom of the screen. You can get in touch with us via LinkedIn, via Facebook, and even via YouTube. We are very glad that you logged in today, Tom. Sorry for the connection problems. Probably you could say briefly a final word as we come to the end of our podcast.
Thank you so much, Anthony. I've been having a problem with my Wi-Fi.
Yes.
I was just trying to thank all the audience and you for giving me this opportunity.
Yes.
Next Saturday I'll share more. What I was just trying to allude to was in the process of termination, both the employer must actually be very careful. The aspect of fairness is very important. And
Sure.
I was tackling on the issue just in brief when you are informing the labor office regarding the termination. Most employers confuse that when you write to the labor office and you tell them that I have terminated Tom, I've terminated ZP, and I've terminated whatever, that is the process. It's not a matter of the employer informing the labor of the decision. The most important thing is that letter should be addressing to open a dialogue box for consultation process to start, so that now the labor office must come to the premise and actually engage the three of you, the employer and the employee, to establish actually that the reasons that the employer is alluding to are real. Because the Employment Act in Section 40 talks about the validity of the reason, and Section 41, Section 43 is talking about the proof of the reason that it is justified. And I wanted to tie that to Section 158 of ILO, Article number 9, Item 3, which talks about that when you send the matter to the respective government organs, they must come and verify actually that those facts are also existing. So the element of termination is not just the Employment Act alone. It is also the ILO, because it speaks about that. It's about the Constitution, Chapter 4, the Bills of Rights, Section 41, which talks about the labor relations, that every employee is entitled to fair labor practices. It's about the Labor Institutions Act, Section 35, which also talks about that. So don't just confine yourself to Employment Act alone. We need to consider also other statutes. Thank you so much. Let's see each other on Saturday, God willing.
Brilliant, brilliant. God willing, indeed. Let's see each other on Saturday. In the meantime, you can get in touch with us through the contacts at the bottom of the screen, through our website, through Facebook, LinkedIn, and YouTube. We are very glad that you came today. We are very thankful for the comments that came. Quite a number did come in. We appreciate our audience for connecting with us. So until next week, keep safe. God bless you. Take care of yourself. Let's see each other on the 27th of August. Thank you very much.
Thank you. Thank you so much.